My name is Shivesh, and it is my pleasure to welcome you to another session in the HR Hot Topics webinar series. For those meeting us for the first time, HR CoLab is a human resources consultancy, and we partner up with SMEs all the way up to large corporate South African employers to stay ahead of what has become one of the fastest moving labor law environments in the world. And we couldn't have picked a hotter topic in the series for today: the employment of foreign nationals in the South African workplace. Quick housekeeping before we dive in. We'll run for approximately 45 minutes, including time for your questions at the end. Please drop your questions into the chat as they occur to you. Don't save them up. This session is being recorded and will be uploaded to YouTube after today. Now, here's my promise to you. In the next 45 minutes, you will walk away knowing three things. One, exactly what the law requires of you today when you employ foreign nationals, what the new Employment Services Amendment Bill, which is currently sitting in Parliament right now, is about to change, including quotas and fines up to R1 million or 10% of your turnover, and precisely what to fix in your business before the inspectors arrive. And I do mean before, because as you'll see, enforcement isn't waiting for the ink to dry. Here's our roadmap. We'll start with why this issue has caught fire in 2026, the numbers and the politics behind it. Then we'll ground ourselves in the law as it stands today: the Immigration Act, the Refugees Act, the Employment Services Act, and what they already demand of you as an employer. From there, a short but important detour into the history, because you cannot understand where this is going without understanding where it came from, including the long-running saga of the Zimbabwean exemption permit. Then we'll look at what our courts have said, and in particular, a judgment called Discovery Health that every HR practitioner in this country should know by name. The second half is all about the future, the new bill, labor market testing, skills transfer plans, ministerial quotas, and those eye-watering penalties. And then we'll land the plane with a 6-point action plan you can start on almost immediately. We'll close with your questions thereafter. If you think of it in terms of outcomes, the first half gives you current obligations, the deep dive lets you assess your exposure, and the action plan turns it all into a compliant recruitment record keeping and audit trail. Let's get into it. Let's start with why you're on this webinar at all. 4 numbers on this slide, and each one tells part of the story. 32.7%. That is South Africa's official unemployment rate as of the first quarter of 2026. And in that single quarter, the economy shed 345,000 jobs. Whatever your personal views on migration, that number is the political fuel behind everything else on the slide. When a third of the workforce cannot find work, the question of who gets hired and whether foreign workers are being used to undercut local wages moves from the business pages to the front pages. 29 May 2026. That's the day the Employment Services Amendment Bill was formally introduced in the National Assembly. This is government's legislative answer to that political pressure, and it is the centerpiece of today's session. It is not law yet, and we'll talk about what still has to happen, but it tells you exactly where the regulation is heading. 10,000. That is the number of labor inspectors the Department of Employment and Labor is recruiting in a phased national drive. Think about what that means practically. Inspection capacity on a scale this country has never had before. And finally, R1 million, or 10% of annual turnover, the proposed maximum fine for repeat offenders under the bill. I want you to sit with that 10% figure for a moment. That is competition law territory. That is a board level risk, not an HR admin issue. And here's the kicker at the bottom of the slide. Joint inspection blitzes. SAPS, Home Affairs, and Employment and Labor together are already knocking on employers' doors where undocumented workers are suspected. So if your strategy is we'll deal with it when the bill becomes law, I'd respectfully suggest that it is not a strategy. The enforcement climate has already changed. I want to take a few minutes to put all of those numbers into context, because the story of how South Africa got here in 2026 is directly relevant to every employer here today. This is not a situation that appeared overnight. Let me quickly walk you through the timeline. In February of this year, the State of the Nation address, President Ramaphosa put employers on notice. He was unambiguous. He said that employers who hire foreign nationals without the required visas will face the full might of the law. He announced 10,000 additional labor inspectors to work alongside SAPS and Home Affairs in coordinated operations. And he warned that the government could no longer allow employers who had been charged and found guilty of employing undocumented foreign nationals to simply pay a fine and carry on. The word he used was imprisonment. That was February. By June, the situation had intensified significantly. Anti-immigration tensions had been building across the country, protests in the Western Cape, KwaZulu-Natal, and Gauteng. And on the 7th of June, the president addressed the nation again. This time he went further. He announced 5 specific crackdown measures. Dedicated immigration courts to fast-track deportations, increased penalties for employers, and a comprehensive approach for migration management. A former interministerial committee led by the Minister of Justice with Home Affairs, Police, Labor, and other departments all working together. He said something in that address that I think deserves to be heard by every business owner and HR professional in South Africa. He said, and I quote, "We cannot have a situation where employers, after being charged and found guilty of violating our laws, merely pay a fine and continue employing undocumented foreign nationals whom they exploit." That statement tells you 2 things. First, the government knows this has been happening. Second, the era of paying a fine and continuing as before is over. And the statistics back it up. By mid-June, before July's blitz even happened, non-compliant employers had already collectively paid more than 770,000 Rand in admission of guilt fines. Several employers had been formally charged under immigration law, and over 40,000 undocumented foreign nationals had been arrested since the beginning of 2026 alone. Over 7,000 in a single month. Then came the 24th of July, which was actually just Friday. The first ever coordinated nationwide blitz. All 9 provinces simultaneously. 3 out of 114 workplaces were found to be compliant. 137 foreign nationals arrested. 546 foreign employees identified in total. But here is the number I want you to focus on. 546, not 137. Those are the people who were arrested. 546 is the total number of foreign national employees found working across those inspected sites. Of those 546, the overwhelming majority were employed by businesses that were not compliant with immigration law, which means they were at risk, and so were the employers. The Deputy Minister Sibiya made the government's position crystal clear. He said, and I'm paraphrasing from his direct statement to the media, "We want to cut the demand. The employment of illegal foreigners is being done deliberately. We are going to continue to conduct these operations across the country." His colleague, Home Affairs Deputy Minister Nzuza, added that while the number of arrests may appear small, the message has been received. EWN reported Deputy Minister Sibiya's latest warning to employers. We are going to be in their offices. Not we might visit, not inspections may occur. We are going to be in their offices. So let me be direct with you about what this means in the context of this webinar's topic. The employment of foreign nationals in South Africa is no longer a back office immigration administration matter. It has become a front page business risk, a presidential priority, and an enforcement target. The three pillars of enforcement, the Department of Employment and Labor, the Department of Home Affairs, and SAPS, are now operating jointly, coordinated at the highest levels of government, with an interministerial committee reporting directly to the president. If you employ foreign nationals, documented or undocumented, you are in the sights of a compliance infrastructure that is being scaled up aggressively and that has a clear mandate from the president to move from fines to prosecution. That is the environment in which today's session takes place. And that is exactly why the legal framework, the permit landscape, and the action plan we are going to work through this morning are not theoretical, they are urgent. So what does the law actually say today before any new bill? 3 statutes from the framework, and I'd like to think of them as 3 doors you have to walk through. Door number 1, the Immigration Act of 2002. This is the gateway question. Does this person have the legal right to work in South Africa at all? No one may employ a foreign national who isn't lawfully entitled to work here. And the Act governs the whole family of work visas. The general work visa, the critical skills visa, intra-company transfers, and the new points-based system, based and designed to attract scarce skills. Keep that points-based system in mind. It comes back later as one of the great tensions in this whole reform. Door number 2, the Refugees Act of 1998. Recognized refugees and asylum seekers have the right to seek employment in South Africa. And here is a distinction that is going to matter enormously. Under the new bill, refugees and asylum seekers are not foreign nationals. They sit inside what I'll call the preference pool, alongside citizens and permanent residents. Hold that thought. Door number 3, the Employment Services Act of 2014. This is the quiet one. The statute most employers have never read. It adds a labor market layer on top of immigration law. It already places duties on employers of foreign nationals, and critically, it is the act that the new amendment bill will expand. That's why it's called the Employment Services Amendment Bill. And then the line at the bottom of the slide, which might be the single most important sentence of the morning. The Labor Relations Act, the Basic Conditions of Employment Act, and the Constitution protect all workers in South Africa, regardless of nationality and regardless of documentation. Our labor laws do not check passports. Remember that line when we get to the case law. This slide is your field guide, the 6 documents you are most likely to find in a hiring pack, and what each one really means for you as the employer. First, the general work visa. 2 words to remember: employee-specific and role-specific. That visa was issued for a particular job with a particular company. A job changes, or the person moves to your company from somewhere else. The visa no longer covers them. And note this: obtaining one already requires proof that no suitable local candidate was available. Sound familiar? That's the bill's labor market testing in embryo. It already exists in the corner of the system. Second, the critical skills work visa for occupations on the government's critical skills list. The holder has more mobility, but here's the trap. The role must generally match the listed skill. If you hire a listed software engineer and deploy them to run your sales team, you have a problem. Third, the intra-company transfer visa. For moving people from a foreign office within your group, it's time capped. It cannot be renewed from inside the country. And take note, it already requires a skills transfer plan. That is the very model the new bill wants to roll out across the board. Fourth, the ZEP and LEP exemption permits. The special dispensations for Zimbabwean and Lesotho nationals, currently valid until 28th of May 2027. There's a whole story here, and we're coming to it in a few minutes. Fifth, refugee and asylum seeker documents. Section 24 and Section 22, respectively, both confer the right to work. Your job is to check the document is current and its conditions are met. And remember, these employees sit in the preference pool, not against any future quota. And sixth, permanent residence. The full right to live and work. No employer tie, no expiry. Verify the certificate once, file it, done.
Sorry,
Now, watch out.
Sorry, Shivesh. The slides are a little bit blurry. Okay, I think it's getting. Maybe we just keep it on for like a little bit, just so everyone can have a good look. Sorry,
Sure.
Sorry for interrupting.
No problem at all. I hope everybody can see it. If you're struggling to view it, it's not a problem. You're more than welcome to reach out to me, and I'll gladly share them with you as well. Now, the watchouts on the right. These are where employers actually get burnt. 1. The endorsement must match the actual job, the actual employer, and the actual location. Read the small print on the visa, not just the expiry date. 2. Diarize expiries 90 days ahead. Renewals take time, and a lapsed visa mid-employment is a crisis you can schedule your way out of. 3. Visitor and study visas allow work only where it's specifically authorized. That's a classic trap with so-called volunteers and interns. And 4, if a document looks suspect, verify it directly with Home Affairs, because employing someone on a forged permit is your contravention, even if you were duped. Documented due diligence is your defense. I do wish to make note as well with this. When it comes to verifying documents such as visas or work permits, while you have the opportunity to engage with Home Affairs directly, you can also reach out to certain service providers who will be able to facilitate that process for you and streamline it for you. Should I give it a few seconds before I move on, Dylan?
Yeah, I think maybe let's keep it up for another minute for everyone just to.
No problem.
And then.
This is a very important slide, and I'd like for everybody to be able to see it as well.
Great. I think we can move on now.
Okay.
All right.
Let's make that concrete. These 4 duties bind you today, not next year, not when the bill passes, today. First, verify before you hire. You must satisfy yourself that the person is lawfully entitled to work in South Africa. And just as important, you must understand the specific conditions attached to their visa or permit. And I want to stress, verification is not a once-off event at onboarding. Visas expire. Permits get extended by ministerial announcement, as we'll see with the ZEP. You need a living system that tracks expiry dates and renewal applications. Second, keep the paper trail. Retain copies of every document that proves lawful employment. The permit itself, your verification steps, the offer, the job description. Here's the rule of thumb I give every client in an inspection. If it isn't on file, it didn't happen. Inspectors don't ask what you did. They ask what you can prove. Third, no inferior terms. A foreign national must be employed on terms and conditions no less favorable than a South African citizen doing the same work. Equal pay, equal conditions. And notice how this connects to the politics. Underpaying foreign workers isn't just a contravention. It is the very wage undercutting that is driving public anger and ultimately this legislation. Fourth, work within the visa. Never require or permit an employee to work outside what their visa authorizes. The wrong role, the wrong employer, the wrong location. Each one of those is a contravention. A chef's visa does not cover a general manager's job, even if it's the same restaurant and even if it's the same promotion. My practical tip on the slide: build a foreign national register. One document. Every foreign national on your payroll, their visa type, the conditions of the visa or the permit, the expiry date, and the status of any renewal or waiver application. If you do only one thing after this webinar, do that. Now, the title of this webinar promised you history. And I promise this detour earns its place, because the pattern it reveals tells you exactly where we're heading. South Africa's economy was quite literally built on foreign labor. From the early 1900s right through to the 1980s, the mines and the farms ran on cross-border contract workers from Mozambique, Lesotho, Malawi, and Zimbabwe, under a migrant labor system that was rigidly controlled by the state. The state decided who came in, for how long, and on what terms. Democracy brought a rethink. The Apartheid-era Aliens Control Act gave way in 2002 to the Immigration Act, a modern skills-based framework that shifted responsibility onto employers. Then came the Zimbabwean crisis. From the mid-2000s, economic collapse and political violence drove millions of people across the Limpopo, and from 2009, government responded with special dispensation permits that regularized hundreds of thousands of workers. More on that saga on the next slide. In 2014, the Employment Services Act added its labor market layer. And then the real turning point, 2022, the National Labor Migration Policy, the NLMP, which for the first time explicitly proposed quotas on foreign workers and the active prioritization of South African job seekers. And in 2026, the Employment Services Amendment Bill takes that policy and turns it into a draft law. So look at the pattern across a century. South Africa has always depended on foreign labor and has always struggled to regulate it. What we are watching in 2026 is the most assertive attempt yet to put the state back in control of who gets hired. And here's why the history matters for your planning. This bill is not a bolt from the blue or a passing political gesture. It is the culmination of a 15-year policy arc. Details may change in Parliament, but employers should work on the assumption that something like this will become law. Let me bring that history right up to date with the story of the Zimbabwean exemption permit. Because if you employ Zimbabwean or Lesotho nationals, this affects people on your payroll right now. It starts in 2009 with the dispensation for a Zimbabwe permit, created to regularize workers fleeing the crisis. In 2017, it became the ZEP, the Zimbabwean exemption permit, held by roughly 178,000 people. Then in 2021, Cabinet announces termination. No further extensions. Everyone must migrate to mainstream visas or leave. Enter the courts. The Helen Suzman Foundation took the decision on review. And in 2023 and 2024, the courts ordered government back to a fair consultative process. The result, the permits have been extended. They are currently valid until the 28th of May, 2027. And there's a further concession until the 30th of June, 2027, covering people with pending waiver and appeal applications. And I need to clear up some confusion from April this year, because you may have seen the headlines. A deputy minister's television comments were widely reported as opening a pathway from ZEP status to permanent residence. Within 48 hours, Home Affairs corrected the record categorically. ZEP holders do not qualify for permanent residence, and there has been no policy change. What is happening is a public consultation under the white paper review, with recommendations due to Cabinet by the end of the 2026-27 financial year. So what does this mean for you as an employer? 3 things. Get proof of permit, status, or of pending application on file for every ZEP and LEP holder you employed now. Remember that an employee with a pending waiver or appeal may lawfully continue working. So do not dismiss reflexively when a permit date passes. And more broadly, understand that 178,000 people's right to work currently turns on ministerial decisions and court orders. Track it actively and never assume an extension. And that phrase, do not dismiss reflexively, takes us straight to the courtroom. This slide is the legal heart of the session, and it corrects the single most dangerous misconception in this whole area. The idea that an employee with a permit problem has no rights and can simply be let go on the spot. The foundational case is Discovery Health versus the CCMA. The facts briefly: an employee's work permit fell away, and the employer treated the contract as automatically void. No hearing, no process, just gone. The labor court disagreed, and its reasoning has shaped this area of law ever since. The court held that a foreign national, even one without a valid work permit, can still be an employee as defined in the Labor Relations Act, which means the CCMA has jurisdiction, and that person can pursue an unfair dismissal claim. Why did the court reach that conclusion, you may ask? Because the alternative is perverse. If working without a permit stripped a person of all labor protections, you would be handing unscrupulous employers a license to exploit the most vulnerable workers in the country. Hire them cheap, work them hard, and discard them without consequence. The court refused to read the Immigration Act as an invitation to exploitation. The second strand of case law, illustrated by the Nyakudia, and I apologize for the mispronunciation, line of decisions, deals with remedy and process. Yes, if a person cannot lawfully work, reinstatement may be impractical. A court won't order you to employ someone the Immigration Act says you can't. But, and this is the crucial point, the absence of a practical remedy does not make the dismissal fair. Courts will intervene where employers bypass fair process, and compensation can and does follow. Substantive fairness and procedural fairness always apply. So what does good practice look like when you discover a permit problem? It is the start of a process, not the end of one. Suspend if you must, investigate, give the employee the opportunity to respond and to regularize their status. Remember those pending ZEP waivers and document every step. And the banner at the bottom of the slide is the sentence I want you to quote in your next management meeting. It is never open season on foreign national employees. Every termination, whether it's driven by a permit lapse today or one day by a quota, must still pass the LRA fairness test. The Employment Services Amendment Bill. Let's orientate ourselves before we dive into the detail. On the left, what it is. Introduced in the National Assembly on the 29th of May this year. It amends the Employment Services Act of 2014, and it gives legal force to that 2022 National Labor Migration Policy we spoke about. It's designed to align with the Immigration Act and the Refugees Act. And to be clear about status, it is a bill, not an act. It still faces committee scrutiny and public participation. There is a real window to influence it, and we'll come back to that. On the right is the definition that changes everything. Who counts as a foreign national for the purposes of all these new rules? And it's easiest to define by exclusion. You are not a foreign national under this bill if you are a South African citizen, obviously, but also if you're a permanent resident, a recognized refugee, or an asylum seeker. Those four groups together form the preference pool. The people you'll be required to consider first when you recruit, and the people who do not count against any quota. Now, here's the practical insight most employers miss. When the business count their foreign workers, they typically count everyone born outside of South Africa. Apply this definition properly. Strip out your permanent residents, your recognized refugees, your asylum seekers, and many employers' numbers shrink dramatically. Before you panic about quotas, rerun your headcount against this definition. Some of you will find your exposure is far smaller than you feared. Others will find the opposite, and it's better to know now. Deep dive number 1. 2 new duties that will reshape how you recruit. First, labor market testing. Before recruiting a foreign national, you will have to satisfy yourself in a manner that regulations will prescribe, that no suitably qualified citizen, permanent resident, refugee, or asylum seeker is available for the position. In other words, test the preference pool first and be able to prove you did. Expect the regulations to demand things like evidence that the post was advertised, records of who applied, and how they were screened, and documented reasons why preference pool candidates were not appointed. If that sounds like an administration burden, it is. But here's the reframe. It is also just disciplined recruitment. Advertise properly, screen fairly, document your decisions. Employees who start behaving this way now will find the transition painless and will have a beautiful paper trail if a dispute or an inspection ever comes. Second, skills transfer plans. Today, formal skills transfer obligations attach mainly to intra-company transfer visas. The bill would generalize that. A skills transfer plan would be required for positions held by foreign nationals across visa categories. Practically, that means identifying an understudy from the preference pool, setting development timelines, and tracking progress. The minister may exempt certain sectors or categories, but my advice is to plan for the default, not the exemption. And let me give you the balancing view, because this bill has serious critics. Commentators point out an obvious tension. Home Affairs has just built a points-based immigration system designed to attract critical skills into South Africa. While this bill layers testing and transfer duties that make hiring those same people harder. That contradiction is one of the big questions Parliament will have to resolve, and it's a reason the final version may look different from the current draft. Deep dive 2. And this is the provision generating all the headlines. Quotas. The bill empowers the Minister for Employment and Labour to set maximum quotas for the employment of foreign nationals. And the power is broad. Quotas can be set by economic sector, a maximum percentage of foreign nationals in, say, hospitality or agriculture or transport. They can be set by occupational category within a sector. And they can be set geographically, regionally, or even nationally. Government has signaled the focus will be on lower skilled sectors where foreign workers are concentrated. Before anyone reaches for the panic button, look at the escape valves on the dark panel. First, critical skills. Exceeding a quota may be justified where a position generally requires critical skills. Second, ministerial exemptions. Employers will be able to apply for exemption from a quota. And third, procedurally very important, quotas do not self-execute. The minister must first consult the Employment Services Board and consider public comments. That means there will be warning and there will be a window to respond sector by sector. And the fourth reassurance comes from everything we said at slide 8. If a quota ever forces changes to an existing workforce, Discovery Health and the LRA are still standing right there. Any resulting dismissal must be substantively and procedurally fair. Proper consultation, fair selection, fair process. A quota is not a magic wand that vaporizes employment rights. For balance, again, business and economists have pushed back hard on this provision, warning that quotas could create labor shortages in dependent industries, chill investment, and invite constitutional challenge. Expect vigorous debate in the committee process, but for your risk planning, assume some form of quota power survives. And make sure you know your numbers if a quota landed in your sector tomorrow. Deep dive 3. What happens if you get this wrong? And I'll be blunt. This is the slide to screenshot for your CFO. The bill proposes escalating fines imposed by the Labour Court, 100,000 Rand for a first offence, 200,000 for a repeat offence within 3 years, and for multiple contraventions, up to R1 million or 10% of annual turnover. Let me say that again. 10% of turnover. For a business turning over 50 million Rand, that is a 5 million Rand exposure. These penalties are materially higher than anything under the current Immigration Act, and criminal sanctions, including imprisonment, remain on the table for unlawful employment. That percentage of turnover mechanism is borrowed straight from competition law, and it sends a deliberate message. Government wants this discussion discussed in boardrooms, not just in HR departments. If foreign national compliance is not on your risk register today, this is your prompt to put it there. And the warning panel at the bottom bears repeating one more time, because it is the drumbeat of this whole session. Enforcement is not waiting for the bill. 10,000 inspectors are being recruited. Joint SAPS, Home Affairs, and labor blitzes are already targeting employers of undocumented workers under powers that exist today. For example, the blitz that took place on Friday, the 24th of July. So let me leave you with the question I ask every client, and I'd like each of you to answer it honestly for your own organization. If inspectors arrived at your premises tomorrow morning, could you produce a complete current file for every foreign national on your payroll within an hour? If the answer is anything other than an immediate yes, the next 3 slides are for you. So where is all of this going? 3 phases to watch. Phase 1 is now. The bill is in the parliamentary process, committee scrutiny, and public participation. And I want to frame that as an opportunity, not just a waiting period. If this bill affects your sector, and if you're on this webinar, it probably does, you or your employer organization can and should make submissions. This is the moment the detail is still movable. Phase 2 is the 2026 to 27 horizon, the broader white paper review on citizenship, immigration, and refugee protection, with recommendations on the future of the ZEP and LEP regimes due to cabinet by the end of the financial year. For the 178,000 permit holders and their employers, expect more turbulence before there's certainty. Phase 3 is enactment. Whenever it comes. And here's a piece of hard-won wisdom about South African labor legislation. The Act gives you the skeleton. but the regulations give you the compliance detail. How market testing must be evidenced, what the actual quota percentages are, how exemption applications work, all of that will live in regulations published after the bill passes, which means this story runs well into 2027. And staying current is itself a compliance task. And keep an eye on the open tensions listed at the bottom. Quotas versus the points-based critical skills system, business pushback on the investment impact, likely constitutional challenges, and the practical question of whether the state can enforce what it legislates. Any of these could reshape the final law. The direction of travel, though, more control, more documentation, more accountability. That is fixed. Plan for it. This all brings us to the part of the session you can actually implement today. 6 moves to make before enforcement tightens. Move 1, audit your register. Build or refresh that foreign national register we spoke about. Every foreign national, their visa type, the specific conditions, the expiry date, and the status of any renewal or waiver application. Include your ZEP and LEP holders and their pending applications. This single document is the foundation of everything else. Move 2, rebuild the file. For each person, a copy of the permit, evidence of your verification steps, and the job specification. Inspection ready means retrievable in minutes, not days. When the inspectors arrive, that file is your first and best defense. Move 3, fix your recruitment records. Start behaving as if the labor market testing already applies. Advertise the role. Keep your screening records. Document why preference pool candidates weren't appointed. It costs you almost nothing today. It's defensible best practice in any dispute. And the day the bill commences, you're already compliant. Move 4, draft skills transfer plans, starting with your critical roles held by foreign nationals, a named understudy, a development timeline, and evidence of progress. Don't wait for the templates to be prescribed. The discipline matters more than the format. Move 5, check pay parity. Compare every foreign national's terms and conditions against local employees in the same role. If you find gaps, close them. That's a live legal duty today, and it's also the reputational fault line in this whole debate. And move 6, the one that prevents the most common own goal that I see. Train your managers. The classic disaster is a well-meaning line manager who discovers a permit issue on a Friday and dismisses the employee by close of business. You now know why that's an unfair dismissal claim waiting to happen. Fair process applies to every foreign national employee. No summary dismissals, ever. 6 moves. None of them requires new law to exist. And every one of them reduces your risk from the moment you do it. Let's bring it all home. If you remember only 3 things from the session, make it these. 1, the duty is already live. Verification, record keeping, equal terms, and visa condition compliance bind you today. And the enforcement machinery is already scaling up around you. Compliance is a present tense obligation. 2, the bill raises the stakes dramatically. Labor market testing, skills transfer plans, ministerial quotas, and fines up to R1 million, or 10% of turnover. It isn't law yet, but the smart move is to assess your exposure now while you can still fix things quietly and cheaply. And 3, fair process never switches off. Not for a lapsed permit, not for a quota, not ever. Discovery Health guarantees that every foreign national employee carries the full protection of our labor law, and that every termination must be substantively and procedurally fair. As promised, this webinar will be available on YouTube for ease of reference and guide. So the only question left is, what should you do next?